And so for those who did not join in previous classes, I will present myself again. My name is Juan Pablo Hernandez. I am the co-administrator for Guatemala in the Jessup competition. I am also a Guatemalan diplomat in charge of the 6th committee, which deal with legal affairs in the UN. And I am at your disposal if you have any questions regarding the subjects that we will be addressing tonight. And so again, tonight's subject is the peaceful settlement of international disputes. We, as part of the Guatemalan administration for the Jessup, are very well aware that some of these subjects touch upon the issues that are presented within the next year's Jessup problem. And so we will be avoiding those as usual. And for that purpose, we will be addressing the issue of peaceful settlement of disputes from the perspective of the UN collective security system and the role of the prohibition on the use of force in the settlement of disputes between states. And so the subjects to be addressed today are on the screen, as you can see. And for those who were connected in our first session, which dealt with an introduction to public international law, we will be taking off from the subject of international law as a horizontal system for them to spring off into the subject of dispute settlement. And as usual, if you have any question, you can write it in the chat, or we will have a slide at the end where you can ask your questions, if any. Tonight's session, as many others that I have given this year's Jessup School, will last about an hour and a half. So take that into account. And so, as I was explaining in the session regarding introduction to public international law, one of the essential aspects of the international system is that it is a system that has a horizontal structure. And what I meant by this assertion is that international law, unlike many, if not all, systems of domestic law that you may be inclined to compare it to, international law does not have a structure whereby there is a sovereign that has power over subjects in the strict sense. We do not have a structure that recognizes executive, judicial, or legislative powers in the sense that these powers exist in domestic systems. And so you will see, for example, that even though we will be addressing its powers and its capabilities and its responsibilities in this session, the UN Security Council, for instance, does not have an absolute or a general executive power. It has a power to maintain and restore international peace and security according to the mandates of the Charter. The International Court of Justice itself, as we will be addressing at the end of this session, also does not have an absolute or general dispute settlement power. It only has a dispute settlement power in respect of disputes which are submitted to the court according to the consent of the litigating parties. And this is true for many other judicial systems in international law. And so we do not have a binding system of courts as you may find it in domestic systems. And we also do not have any legislative power in the sense that we have it in domestic systems. There is no international universal Congress or Parliament that has the power to enact laws. We have the states, which through their practice and through their agreements, create international law according to the sources that were explained in the first session. And so in a sense, all states in the exercise of their sovereignty have all of these powers within themselves. They all have the power to create the law, that is either through agreements with other states or through participation in international custom through their own practice. They have the power even to create law unilaterally through unilateral acts and unilateral declarations as recognized in international law. They have the power to interpret the law. They have the power to apply the law. And in some circumstances, as allowed by international law, they have the power to execute it, to enforce it. And perhaps the most salient situation in which a state has the power to take the law into its own hands is in the context of the use of force which will be one of the main subjects addressed today. It is important to note as well that this executive power of states, as I mentioned before, is not absolute. It is subject to the limits of international law, and it also does not need to involve the use of force. For example, one of the concepts that is explained in many international relations and international law books is the concept of sanctions, the legality of which may or may not be challenged in specific cases. We see in the law of state responsibility, for example, the power of states to establish and execute countermeasures as a circumstance that precludes the wrongfulness of certain acts, whereby states have the power to, in a way, to take the law into their own hands, to suspend the application of certain international obligations when another state to which that obligation is owed has failed to perform its own obligations. And so international law has, in a sense, the function or the mandate of ensuring that such executive powers, including the executive power to use force, is subject to strict limits to maintain friendly relations between states. And this concept of friendly relations between states as maintained by international law has one of its pillars in the concept of sovereign equality. As I mentioned before in our lesson on Introduction to Public International Law, sovereign equality is codified in the UN Charter, Article 2.1, and it is recognized by the International Court of Justice as one of the fundamental principles of international law. This was stated by the court in its 2012 judgment in the case concerning jurisdictional immunities of the state between Germany and Italy. This principle of sovereign equality is not only one of the essential and fundamental rights of states, it is also the source of many obligations, including the obligation of to guarantee state immunity as recognized under international law, a subject that was addressed then, and I will not be delving into further. The principle of sovereign equality in that respect encompasses many other concepts, such as the protection of national jurisdiction and the protection of territorial sovereignty. And it is the concept of territorial sovereignty that will be most important in tonight's session. And so to set the stage, the subject of the peaceful settlement of disputes is best understood from the perspective of international law when understanding the role that war or armed conflict has played in international relations over many decades. For those of you who have studied international law recently, you are aware that as of today, the use of force and the threat of force is prohibited under international law. It is prohibited in the Charter, it is prohibited in customary international law, and exceptions in this respect are fairly limited. We will address them later in this presentation. But what you have to understand is that the use of force wasn't always prohibited. It wasn't always a measure of state power that was contrary to international law. In fact, for many years, I would even say for the majority of human history, war was conceived as a valid, as a lawful instrument of foreign policy and a lawful instrument for territorial expansion. The name for it may vary over the years. The concept of war is not, as you may know, is not a term of art in international law. In international humanitarian law, for instance, one prefers to utilize terms like armed conflict. War is rather a political concept that is related to many other legal concepts that we find in international order. Now, the process by which war became or was transformed from a valid instrument of foreign policy to a prohibition under international law was not a simple process. And of course, the possibility of using force against other states and under which circumstances this could be used has a very long history. We will not be going into all of the specifics regarding how just war or valid war was conceptualized in ancient writings, for example. We will focus on recent history. And perhaps the most important place to start is the Hague Conferences of 1899 and 1907. This is the moment in history in which the value of concepts like disarmament, like the regulation of war, the regulation of armed conflict, the treatment of certain categories of persons, and of course, the settlement of disputes through peaceful means was brought to the forefront. And many subjects of international law that relate to these concepts will be found, will find one of its roots in these conferences, also called the peace conferences. We will not be addressing these conferences in any detail, but it is important to recognize that they played an important role in recognizing that the disputes between states may not need to be resolved through the use of force, and that when the use of force was to be utilized, it had to be limited in certain respects and with respect to many principles of international law. Even many concepts of international humanitarian law are still defined by reference to these conferences. And so we here see the seed of what will later become the prohibition of the use of force and what we call now the jus ad bellum, the law that governs the use and the threat of force. A further development in the history of the use of force in the prohibition of war, to be more precise, is found in the 1919 Covenant of the League of Nations, which, as you may know, was the predecessor of the United Nations Charter. Now, unlike the UN Charter, the Covenant of the League of Nations did not prohibit the use of force as we see it in current international law. The Covenant on the League of Nations did recognize that in some instances, the resort to peaceful settlement of disputes was to be preferred. And in fact, although it did recognize the use of force as a possible instrument for the settlement of disputes, it was subject to requirements, one of which was that the states would need to resolve their disputes or try to resolve their disputes through peaceful means during a certain period of time. And if peaceful means were exhausted in that period of time, then states could resort to the use of force. So the use of force was not prohibited under the Covenant of the League of Nations, but it was already subject to specific limitations. The most significant development in the history of the prohibition of the use of force is found in the 1928 Kellogg-Briand Pact. You may find this treaty also under the name of the Treaty on the Renunciation of War, which is its official name. And this is a rather simple treaty. It provides that state parties to this treaty renounce war as an instrument of public policy, of foreign policy, as a mechanism for the settlement of disputes between states. And of course, this is an instrument of treaty law. So it would only be binding for those states that would become parties to the Kellogg-Briand Pact. But over the years, as the developments of the jus ad bellum happened, this renunciation of war became generalized in the relations between states. An important detail that is very interesting, in fact, is that many states that ratified the Kellogg-Briand Pact established reservations to it as regards the right to self-preservation, the rights to self-defense, or other rights that were related in some way to self-defense or self-preservation. The concept of self-defense can be traced back, as we know it today, it can be traced back to some of these reservations. So, of course, the Kellogg-Briand Pact was an instrument of treaty law. It was not binding for third states, but it was a very important development in the relations between states, because it was the first time that the use of force was recognized as an instrument that was not valid under international law. And of course, those states that became parties to this pact would not be allowed by obligations under international law to resort to the use of force. But of course, the prohibition of the use of force as we find it in current international law is grounded on the United Nations system. And it is the United Nations system that provides for the depth that we need to analyze when delving into the subject of the peaceful settlement of disputes. So in 1945, the UN Charter is essentially adopted by states in the San Francisco Conference. It is the first time that we find an express declaration that states shall not resort to the use of force or the threat of force in their international relations as a multilateral treaty to which the vast majority of the international community was a party. And so this is one of the founding principles of the United Nations, alongside the recognition of human rights and self-determination. And you will come to realize that the prohibition of the use of force, as we understand it today, is very deeply intertwined with the concept of the protection of human rights and the preservation of state sovereignty as a principle of international law. And so the UN Charter doesn't only establish a prohibition of the use of force, it also establishes a complete system of collective security. And this principle and this system of collective security is further developed by the acts of states and the decisions and resolutions of United Nations organs that are dealing with the implementation of the Charter. Two of the most important developments after the UN Charter are listed in the slide before you. The first is the 1970 Friendly Relations Declaration, which develops very many principles of international law that deal, as the name indicates, with the friendly relations between states in accordance with international law. Some of these principles are the prohibition of the use of force, the prohibition of interference in the internal affairs of other states, and the exercise of the right to self-determination. These are some of the most important pillars of the UN system. And so the Friendly Relations Declaration is an important development in the prohibition of the use of force and the threat of force. And in fact, the International Court of Justice recognized in its 1986 Nicaragua decision that the Friendly Relations Declaration, at least as it pertains to the principle of non-intervention and the principle of the prohibition of the use of force, is a codification of customary international law. And a very recent development is the International Law Commission's conclusions on the identification and legal consequence of peremptory norms of general international law, also called the Jus Cogens Conclusions Instrument, or the Conclusions on Jus Cogens. So this is a document emanated from the International Law Commission, which is a subsidiary organ of the United Nations General Assembly, which is tasked with the codification and the progressive development of international law. Those of you who have had the opportunity to study deeply the subject of international law will know that the International Law Commission has played an important role in other areas of international law. For example, the development of articles on the responsibility of states for internationally wrongful acts, provisions on the exercise of the right to diplomatic protection, and the law on international treaties, both between states and treaties involving international organizations. And so the International Law Commission has a broad mandate in this respect. And as part of this broad mandate, the Commission conferred upon a special rapporteur, Professor Diretladi, who has now become a judge of the International Court of Justice, the task of developing conclusions on what constitutes a peremptory norm of general international law. That is to say, a norm of international law from which no derogation is permitted and which can only be modified by a subsequent rule of the same character. What we find in the International Law Commission's conclusions on the subject is that, according to the annex to these conclusions, the prohibition of aggressive war, of the aggressive use of force, is recognized as a peremptory norm of international law. This means that the use of force and the threat of force, which is not otherwise permitted by international law, is considered to be a prohibition that is codified at the level of jus cogens. No state can establish a treaty by which it can opt out or derogate from this prohibition. This is a general prohibition from which no derogation is permitted. And this concept of jus cogens in general has itself had a very difficult history. Even in 1986, when the International Court of Justice had the opportunity in the Nicaragua case to develop the subject of the use of force, even then the International Court of Justice was slow to recognize the prohibition of the use of force as a rule pertaining to jus cogens. It is nonetheless, and even though the International Court of Justice didn't recognize it as such at that time, it is in modern times recognized as a rule from which no derogation is permitted. This is a very important development, indeed, because the recognition of the prohibition of aggressive war as a norm of jus cogens has implications for the methodology that we need to employ in analyzing its application and its development in the practice of states. Because the fact that the prohibition of the use of force is recognized at the jus cogens level means not only, as I mentioned before, that it cannot be derogated through treaty law, it also means that any claim by states or publicists or international organizations that the law on the use of force has developed in any way requires that such a development also have the character of jus cogens. So not any conventional or customary development in the practice of states or in the treaty system is sufficient to modify what is now recognized as the jus ad bellum, or the law on governing the use of force. What you see in this development, coming from war as an instrument of foreign policy into war as a subject that is prohibited at the level of jus cogens, is that what could be conceived as the law governing the use of force, what is called jus ad bellum, has rather become the law prohibiting the use of force, or jus contra bellum, which is a concept that very many international publicists use to describe this body of law. And so where do we end up after this development in international law and international relations? Well, we see that as of today, under the UN Charter system and in general international law, the use and threat of force between states is prohibited. This prohibition is general, and this prohibition is categorical. We find it in Article 2, Paragraph 4 of the UN Charter, which we will analyze further. And what you need to understand as well is that this prohibition is not a standalone rule of international law. Rather, it is a rule that is part of a larger collective security system that is put into effect by the international treaty that is the UN Charter. And so one of the elements that springs out of the recognition of the use of force as a matter to be prohibited by international law is that force becomes a phenomenon of public concern. It becomes a threat to the collective security of states. And this recognition is precisely what animates the mandate of the United Nations Security Council under Chapter 7 of the Charter. It is the recognition that the threat against the peace, the breach of the peace, or the commission of an act of aggression is not only a concern for the state that is the victim of the use of force, but is rather a concern for everyone. For those who remember the lecture on the introduction to public international law, you will remember that one of the aspects of modern international law is that many interests that used to be bilateral or synalagmatic have become multilateral. They have become collective. And the recognition of the prohibition of the use of force as a rule of jus cogens is a further element that proves that the use of force is now subject to such a collective system. Because as a norm of jus cogens, it is also considered to be an obligation that is owed erga omnes. In other words, this is an obligation that is opposable to all states in the international community. Now, the principle that is behind this collective security system is the principle that the use of force is to be subject to some sort of supra-governmental system, or what I like to call an imperfect monopoly of force. So states within their own territory have the monopoly of force. This is something that from the political or international relations perspective justifies and helps to describe the nature of the state. As I mentioned before, the international system is horizontal, which means that no state has in itself the monopoly on the use of force against other states. And in fact, the prohibition under Article 2.4 is intended, indeed, to negate and even refute the idea that any one state can have such a monopoly. Of course, we see that in practice, some states may have more capabilities from an economic or a military perspective than other states, but it doesn't negate the principle that under international law, such practice is prohibited. Now, this means that the United Nations assigns to itself the power to decide when the use of force is or is not warranted from a legal perspective. And this is a mandate that is granted to the United Nations Security Council, but not exclusively to it. And we will see that in a further point in this presentation. Now, this monopoly of force that is granted to the United Nations through its appropriate organs is not perfect. And this is why I call it an imperfect monopoly of force. Force under the UN Charter is to be used in the public interest in very specific circumstances, so as to prevent escalation in the conflicts between states. And in the end, the United Nations Security Council raises itself as the arbiter of when the use of force is or is not permitted. Now, the problem with this is that the United Nations Security Council system has a very important fatal flaw within it. And this fatal flaw, you will be aware of it both by looking at the law itself and by looking at current developments. This fatal flaw is the right of the 5 permanent members of the Security Council to veto decisions on substance, the veto powers. This means, in essence, that one of the 5 permanent members of the Security Council has the power to prevent the Security Council from exercising its mandate if that state considers that it is either against the mandate of the Council or against its own interests to do so. And one of the most important subjects that is analyzed in the debates regarding the application of the Charter and the reform of the Security Council system is what antidotes exist or should exist in the UN system to prevent the abusive exercise of veto powers. As of today, the UN Charter does not impose any restrictions on the veto powers. However, there are very many proposals to circumscribe this right in some way so as to prevent its irresponsible use. To analyze all of these initiatives at the UN level would be beyond the scope of this presentation. However, it is important to analyze that some initiatives at the UN system seek to limit this veto discretion. There are many ways in which this can be done. Some derive these limits from the mandate of the Security Council, in the sense that the veto powers should not be utilized to undermine the mandate of the Security Council. And they find this in the regulation of the Security Council's functions under Chapter 7 of the Charter. Others say that the limitations to the veto power are found in jus cogens itself, in the sense that the veto power should not be used as a mechanism to prevent the Security Council from exercising its functions on the face of atrocities that violate jus cogens. For example, acts of genocide or crimes against humanity. And so it is recognized that if these acts are prohibited at the highest level in international law, then it should be recognized that the Security Council's powers in this respect should also be limited in the same extent. This is a further proposal by some states as to how to limit the veto powers on the face of mass atrocities that violate international law. And one further proposal that that could be made, and this is a purely legal proposal, is to analyze the UN Charter as what it is. The UN Charter as a treaty. If the UN Charter is a treaty, under Article 26 of the Vienna Convention on the Law of Treaties, and under customary international law, the UN Charter needs to be performed in good faith. And as the International Court of Justice recognized in its 2010 Djibouti versus France decision, the principle of pacta sunt servanda, the principle that a treaty has to be performed in good faith, means that if a treaty confers upon a state any discretionary power, this discretionary power also has to be exercised in good faith. It doesn't confer absolute power to the state to withhold performance of its international obligations. Now, these are simply proposals. None of them are part of what we could conceive as the positive law of the Charter, because they have not yet been implemented at the Charter level. But these are arguments that some states have made to limit in some way or circumscribe the discretion that the permanent members of the Security Council have in the exercise of their veto powers. Now, other initiatives do not seek to limit veto powers themselves, but rather to recognize that the use of force is an issue of public concern, and therefore any exercise of veto powers that would prevent the Security Council from exercising its mandate is also a matter of public concern. And thus, it has been proposed that when a Security Council member that has the veto power exercises this right, then the United Nations General Assembly should ask this member state to explain the exercise of the veto power before the whole international community. This is a proposal that usually takes the form of a special emergency session of the United Nations General Assembly, but it does not need to take this form. This is a proposal that brings public scrutiny into veto powers, and therefore brings accountability to those states that have this power and that have to use it in a responsible manner. And a further antidote that is discussed in this context is the United Nations General Assembly's Uniting for Peace resolution. And according to this resolution, rather than limiting the power of states to employ their veto rights or to impose public scrutiny or public surveillance on this right, the United Nations Uniting for Peace resolution establishes a system by which, if by virtue of a veto power, the Security Council is prevented from exercising its mandate, then the General Assembly has the power to issue recommendations for the maintenance of international peace and security. Now, as we will see later in this presentation, the only UN organ that has the power to authorize the use of force is the Security Council. And so the General Assembly does not have the power to authorize the use of force, but it can issue recommendations that the parties to the conflict may or may not, in any specific case, utilize to de-escalate the situation. And so the General Assembly also has a very important role to play in the maintenance of international peace and security under the Uniting for Peace scheme. One example of the Uniting for Peace resolution scheme in action is the recent Russian Federation aggression against Ukraine, where states under the umbrella of the Uniting for Peace resolution called upon the General Assembly to conduct a special emergency session whereby many resolutions were adopted, claiming that this use of force was prohibited under Article 2.4 of the Charter, where some recommendations were issued. For example, the creation of a damage registry, which is now being implemented at the European Union level. And so you can see that this resolution has become operative in practice. And in fact, if I remember correctly, this resolution has been invoked by UN organs no less than 13 times. I believe 5 of those times have been by the General Assembly. And so this is an important piece of the puzzle within the United Nations collective security system, whereby the use of force is an issue of public concern that therefore should concern the whole international community. Now, this United Nations collective security system is the backdrop against which one needs to analyze the threat and the use of force as a concept of international law. Because of course, the UN security system is rather a political structure. It is a policy structure that is intended to limit the policy-making power of certain states or the decisions to be taken in matters of public concern. But it has legal implications. And some of them will be seen when we analyze the issue of self-defense. But it is in this context that we need to analyze the legal concept of the use of force. We will analyze first the use of force, and then the threat of force as a separate concept, both of which, as I mentioned before, are regulated in Article 2.4 of the United Nations Charter. So the first point to analyze is what is to be understood as force, what is to be understood as the use of force, and what is to be understood as the threat of force. So the concept of force itself is a very controversial subject in international law. The starting point for this definition is that force involves the use of military action by one state against another state. This is the basic concept. And so if you encounter a situation in which one state decides to utilize military force against the territorial integrity or the political independence of another state, you will most likely find a violation of Article 2.4 of the Charter. However, this is something that when we analyze it in very specific circumstances, is not very easy to discern. And the reason for this is that for many states, the concept of force also encompasses a broader scope of international pressure or international influence in the policy-making decisions of other states. And so, for example, for many states, the concept of force under the Charter is recognized to encompass forms of economic force. For example, economic sanctions. For some states, economic sanctions are recognized as a breach of the prohibition on the use of force. Now, this is not a position that is recognized at the universal level. This is some states that say it, and one needs to analyze this assertion against the broader scope of the United Nations collective security system, because as I mentioned before, one of the concepts that is related to the use of force is the principle of non-intervention. And as you may recall from the ICJ's Nicaragua decision in 1986, the principle of non-intervention involves the influence by one state through coercive means on the decisions of another state on matters that under international law are recognized as pertaining only to the decision of that state. For example, the selection of a political or an economic system. If a state utilizes coercion to manipulate another state into taking a certain decision or not taking a decision at all, this is considered to be a violation of the principle of non-intervention. And of course, we can debate what constitutes coercion and what doesn't, and to what extent international law recognizes a prohibition of interference in the absence of coercion. These are very complex subjects of international law. But what is true is that from a universal perspective, what is required for force in the context of Article 2.4 to exist is the use of military action by one state against another. And whether economic or other forms of coercion, influence, or pressure are to be conceived as violations of this principle needs to be analyzed on a case-by-case basis, so as to not conflate the prohibition of the use of force with the prohibition of intervention as we understand it in international law. Now, a further element that creates a lot of confusion in the concept of force is a caveat or an alleged caveat that is made at the end of paragraph 4 of Article 2. Paragraph 4 of Article 2 of the Charter says that states shall refrain from the threat or use of force, quote, against the territorial integrity or the political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. And so some authors and some states have argued that if a certain use of force is not directed against territorial integrity or against political independence or against any other principle of the UN, then the use of force is permitted. And this is an argument that is not made by few authors. In fact, this is one of the main arguments that is made to advocate for a more permissive interpretation of the prohibition on the use of force. For example, to authorize humanitarian interventions that are not sanctioned by the Security Council, or to recognize some sort of self-defensive force against non-state actors without the consent of the territorial state, where those non-state actors are located. What you need to understand in this context is that this final phrase in Article 2.4, when we gauge it from the perspective of the preparatory works of the United Nations Charter, this proviso was never intended to be a caveat. It was never intended to be some sort of exception to the use of force or a qualifier of the concept of force. In fact, what you can see in the documents, in the records, the official records of the United Nations Conference on International Organization, which was the conference through which the UN Charter was adopted by states. During the discussions, this precise argument was raised. The preoccupation was raised by some states that adding this caveat could be interpreted by other states as authorizing some forms of the use of force and permitting them without subjecting them to the Security Council authorization. And the response was overwhelmingly to recognize that this phrase was not intended to be an exception to the use of force. One famous phrase in the United Nations Conference on International Organization was the response by the US delegate, where the US delegate said that the purpose of this phrase was to recognize that the prohibition of the use of force was to have no loopholes. And that is the phrase that the US delegate used, no loopholes, that the prohibition would have no exceptions, it would have no spaces for policy making by states. Force was to be prohibited in all cases, except where the UN collective security system so authorized. Now, what is meant by territorial integrity? Well, it is meant to refer to the rights of states to exercise their powers without limitation within their territory. And so, for example, an all-out invasion or intent to dismember the territory of another state would be a violation of territorial integrity, such as we see in very many cases. And in fact, for example, in the Ukraine case, the United Nations General Assembly recognized in 2014 that the annexation of Crimea was considered a violation of Ukraine's national unity and territorial integrity. And this was reiterated in the context of the Russian invasion in 2022 by the General Assembly in its special emergency session, by recognizing that the use of force by the Russian Federation was in violation of the Charter. It stated that the national unity of Ukraine and its territorial integrity needed to be protected within its internationally recognized borders. And so there we can see an understanding by the international community as to what territorial integrity means. It means the power of states to freely exercise their rights and their powers within their territory without military interference by another state. Political independence refers to the power of a state to make decisions on issues of its own concern without the threat or the use of force by another state. And so if a state uses force to influence such policy-making processes by a state, then it is violating political independence. One example of this would be, for example, an invasion by a state to allow or to establish regime change within another state. This would be a violation of political independence, because it would be the use of force by a state to exert pressure and to influence the policy-making process of another state. And otherwise inconsistent principles would be, for example, the use of force against the principle of self-determination of the peoples, or in fact, the exercise of the right to self-determination through the prohibited use of force. This would be a use of force that would be otherwise inconsistent with the principles of the UN. Now, what you see, or what you don't see, rather, in Article 2.4 of the Charter is any qualification as to which kinds or which degrees of force are prohibited. And so the question that would arise is whether there is a de minimis standard to consider whether the use of force is inconsistent with international law. And the answer is that there isn't any. So any sort of force would be a violation of this principle. This could be a mere frontier incident, or this could be an all-out invasion. Both of them would be, to certain degrees, in violation of this principle. Now, whether these two forms of the use of force represent the same threat to the collective security system is a whole other question. And this is a question to be resolved by the Security Council in the exercise of its mandate under Chapter 7. Another question is whether any use of force justifies the response by the victim state through the exercise of the right to self-defense. This is another question, and we will analyze it later in this presentation. But in principle, any resort to force by states, whether it be of a higher gravity or a lower gravity, would in principle be in violation of Article 2.4, because precisely as the US delegate said in the UN Conference on International Organization, this principle has no loopholes. And the only way in which the use of force is permitted is through the United Nations collective security system. And so this is what the concepts of aggression and armed attack refer to. We will analyze them in the context of the right to self-defense. Now, another subject is the concept of cyber attacks. In the context of cyber attacks, it is a rather difficult question to analyze whether in certain circumstances the use of force, the prohibition of the use of force has been violated. And so some of the concepts that are analyzed in this context is whether the use of force constitutes an armed attack, or whether it constitutes cyber aggression. And there is no consensus in international law as to when this threshold is crossed, because a specific use of cyber influence could be considered, for example, a violation of the principle of non-intervention, or a violation of the so-called principle of non-interference, or it could be a violation of the prohibition of the use of force. And there is no universal criterion to distinguish between these different forms of influence. Or in fact, the exercise of cyber influence could not be prohibited at all. This could be a question of gravity, this could be a question of means, this could be a question of what the target was, and what was the purpose of the cyber campaign. And so whether or not a cyber attack violates Article 2.4 needs to be analyzed on a case-by-case basis. And even more, whether a cyber operation is considered to be an armed attack in the sense of Article 51 of the Charter is also a question that needs to be answered on a case-by-case basis. And so that is the law as it stands regarding the use of force. We have it as a prohibition under international law. Now, Article 2.4 of the Charter doesn't only mention the principle of the prohibition on the use of force. It also mentions that states are obligated to refrain from the threat of force, also called the threat of the use of force by some authors. And so the question then is, what falls within this concept of the threat of force, the threat of the use of force? Because of course, international law should not, as a matter of policy, prohibit any sort of assertion by a state that it has a readiness to use force, or it is willing to use force, or that it has force to be used. For example, a state that that has nuclear weapons, take that as an example, a state that has nuclear weapons that ascribes to the system of mutually assured destruction, the MAB system, or to the policy of deterrence, which was so prevalent during the Cold War between nuclear weapon states. The International Court of Justice was slow to recognize in its 1996 nuclear weapons advisory opinion that such practices were in themselves prohibited by international law. And so the question remains, what is a threat of force and what is not? So according to the ICJ, in its advisory opinion on the legality of the threat or use of nuclear weapons in 1996, and you can see the paragraph there quoted in the slide. For the court, first of all, threat of force is understood to refer to the signaled intention to use force or the signaled readiness to use force. So the mere fact that a state possesses a certain weapon does not in itself means that the state is signaling an intention to use it. For example, there needs to be an assertion or some sort of conduct by the state that signals the intention to use it, that signals the intention to resort to force. And so this is something that needs to be interpreted in the facts of the case. And if it is an unilateral declaration, according to the law that governs unilateral declarations. And this is not a question that is easy to answer in specific cases. So it needs to be analyzed with a lot of care, because a threat of force, if established, is inconsistent with international law. Now, the mere signaled readiness to use force is not per se illegal. So that is one of the questions that with which the International Court of Justice was faced in its 1996 nuclear weapons advisory opinion. The court was faced with the question whether such policies of mutually assured destruction or policies of deterrence were inconsistent with the law on the use of force, the law of the Charter. And the court said, well, the policy of deterrence is a particular manifestation of the threat of force in certain circumstances if it constitutes a signal intention to use force in violation of the Charter. And so the question before the court was, what is a threat of force within the scope of the Charter? And what the court said is that, and quote, I quote here, whether or not a signal intention to use force, a threat of force, is considered a threat under Article 2, Paragraph 4 of the Charter depends upon various factors, was the very vague and ambiguous phrase by the court, as usual. It depends upon various factors. And the court says, quote, if the envisaged use of force is in itself unlawful, then the stated readiness to use it would be a threat prohibited under Article 2, Paragraph 4. And so the notions of threat and use of force under Article 2, Paragraph 4 of the Charter stand together in the sense that if the use of force itself in a given case is illegal, for whatever reason, the threat to use such force will likewise be illegal. In short, even if it is to be lawful, the declared readiness of a state to use force must be a use of force that is in conformity with the Charter. And I end the quote there. So this is a paragraph that has been quoted extensively in the legal literature to describe what is the standard to be imposed upon Article 2.4 to determine what is a threat of force and what threat of force is prohibited. So one of the factors that is claimed by some authors is that a particular readiness to use force or a signal intention to use force only constitutes a threat of force under Article 2.4 if the underlying use of force that is being threatened would be inconsistent with Article 2.4. And this interpretation, in my opinion, is incorrect. This is not what the court is saying. So this would be tantamount to saying that the threat of force is only a threat of force if it is illegal. And this is a rather circular argument in a sense, because it would mean that the concept of threat of force is different from the use of force. If you remember, as I said before, the international definition of the use of force under the Charter recognizes any use of military action by one state against another. And so this is prohibited in all cases, but it doesn't mean that a particular action only constitutes the use of force if it is illegal. And so to accept this argument in the threat of force would likewise be circular and rather confusing. What I personally understand the court to be saying in this context is that a threat of force is the signal readiness to use force or the signal intention to use force, end quote. And then this threat is unlawful if the force that is to be threatened is also unlawful. So, for example, the threat to exercise the right to self-defense in accordance with international law is not a violation of Article 2.4, because if the state uses this force in self-defense in accordance with international law, then the state is not violating Article 2.4. So it appears that the use of force and the threat of force are, to some extent, coextensive concepts, as the court says precisely in this paragraph. So, and this is a very confusing subject in a sense, because we are not dealing here with particular conducts by states, with particular actions, or even military actions. We're dealing with declarations. We're dealing with attitudes of states. And every time we are dealing with attitudes, with intentions, with declarations, with statements by states, the question of the interpretation of those statements, of those attitudes, is always very difficult. And so the concept of the threat of the use of force needs to be interpreted with a lot of conscientious understanding of the UN security system, as well as the larger international law environment of such a declaration. Now, up to this point, we have been dealing with the prohibition of the use of force. We will now deal with the exceptions to this prohibition. Now, as I said, the prohibition of the use of force is recognized as a rule of jus cogens. As I said, this is a norm that it does not allow for any derogation. But it doesn't mean that it doesn't allow for any exception. The question that arises here is, what is the character of such exceptions? So there are two possibilities here. And this is a very theoretical and very difficult question of international law. This is not a practical question, because in the end, if we fall within one of the exceptions, we would not be recognized as violating the norm of jus cogens. So this is rather a question for the lawyers to answer. And you know how lawyers like to create classifications and distinctions where there isn't any in practice. And so let's tackle this question as lawyers. What is the character of an exception to a jus cogens norm? So there are two options. The first option is that the exception itself is built into the rule. And this means that for example, the prohibition of the use of force only encompasses the use of force that is not otherwise exempted by international law. Or as the International Law Commission's conclusions on jus cogens says, that what international law prohibits is the aggressive use of force. So there we are with one theory. The other theory is that the exceptions themselves are recognized as independent jus cogens norms. And where we can see this distinction between these two theories, if you're interested in delving more deeply into them, we can see them in an exchange of blog posts in the European, in the blog of the European Journal of International Law, EJIL Talk, if you're interested in looking into them. There are two recent blog posts that are very interesting, dealing with the ongoing situation in the Gaza Strip, whereby Professor Milanovic made a blog post dealing with the complex application of the principle of the prohibition of the use of force in the situation in Gaza. And he made the assertion that the concept of self-defense is only relevant when one analyzes it within the purview of the prohibition of the use of force. So, if the prohibition of the use of force is not engaged, then the principle of self-defense also, likewise, cannot be engaged. This was the thrust of his proposition. And many authors have responded in the comments and in further blog posts that this may not be correct, because according to them, the principle of self-defense is a self-standing principle, is a freestanding principle that stands together with the prohibition of the use of force. And so the principle of self-defense doesn't only exempt the use of force, but it may also exempt some other international measures by states that may violate other obligations. And so which of these two alternatives one adopts is not an easy question to answer. Some answers may be found, for example, in the International Law Commission's articles on the effects of an armed conflict on international treaties. If you're interested, you can look at those articles, because there it is analyzed whether an action involving the use of force in self-defense that is lawful under international law exempts a state from violations of obligations that do not involve the use of force. For example, if a state violates, for instance, an obligation relating to the prohibition of certain trade measures, for example, a WTO inconsistent measure, whether the principle of self-defense would exempt the state from such a violation. This is not an easy question to answer. In fact, there are very many theories. So if you're interested in it, I encourage you to look into it. And if you have any further questions regarding that, you can send me an email and we will have an exchange on that very interesting topic. Now, whether or not we consider self-defense or the other exceptions to the use of force to be their own rules, whether they are part of the prohibition, built into the prohibition, the truth is that the use of force is prohibited at the Ius-Cogens level. My own understanding of this follows the International Law Commission's apparent understanding of this subject in the conclusions on Ius-Cogens. So for me, what is prohibited under international law is the threat or use of aggressive force. And so to the extent that one recognizes that the use of force in application of a UNSC authorization or mandate, or in the exercise of self-defense, is not aggressive, then it is not prohibited. And we will delve this more deeply when we deal with exceptions, with further exceptions outside of self-defense and UN Security Council authorization. Now, what you can surmise from what I have been explaining is that there are two exceptions to the use of force that are widely accepted in the international community. The first is the right to self-defense, which is described as an inherent right in the Charter, and it is recognized in Article 51. And the second is the authorization by the United Nations Security Council acting under Chapter 7 of the UN Charter. There are other exceptions that some have proposed and have floated in the international literature and in the state practice. For example, the principle of humanitarian intervention, the principle of consent, and the so-called extraterritorial use of force against non-state actors. So we will analyze the merits of such exceptions at the end of the treatment of the use of force. But to understand this, we need to take into account that from a universal perspective, from a generally accepted perspective, only two exceptions exist, which are self-defense and the authorization by the Security Council. And if you ask my opinion, from my perspective, these are the only exceptions that exist in international law. Any other use of force that is not authorized by self-defense or a United Nations Security Council authorization under Chapter 7, to my view, would be considered an act of aggression. Although we can have that discussion some other day, because this is a very interesting discussion. So the first exception is self-defense. Self-defense is the manifestation of a right to self-preservation. some sort of self-help measure. And so it is a manifestation of the recognition of international law as a horizontal system of governance, whereby the application of international law is in the hands of states who can delegate this right to international organizations, or who can exercise them themselves in accordance with international law. And self-defense is a manifestation of such a principle. But what you can surmise from what I have been explaining throughout this presentation is that such forms of self-help are not absolute. They are not only not absolute, but also they do not take very many forms. We can find, for example, a manifestation of self-help principles in the regulation of countermeasures, as I explained in the context of the horizontal international law system. We can find that to some extent in the discussions regarding the concept of sanctions, and of course in self-defense. But this is not a concept that is widely understood. And in fact, if you see the 1949 Corfu Channel decision by the ICJ, the court says that such self-help measures can only be exercised in accordance with international law. There are certain forms of self-preservation that are not accepted. For example, unilateral measures of intervention in the territory of another state for the preservation of evidence, which was what the United Kingdom did in the Corfu Channel case against Albania. The court recognized this to be a violation of Albanian sovereignty, and it stated that such forms of self-help do not have a place in the international system. And so it is understood that by encompassing self-defense within such system of self-help, one needs to understand that self-defense is also subject to very strict limitations, so as to ensure that the prohibition on the use of force is not bypassed. And so Article 51 of the Charter says that the right to self-defense exists in response to an armed attack. What is an armed attack? Well, the International Court of Justice stated in the Nicaragua case in 1986 that an armed attack encompasses the sending by or on behalf of a state of armed forces, which may be regular forces or irregular forces that are sent on behalf of the state. And this involves questions of state responsibility, such as attribution, which we will not be delving into in this lesson. But the concept is clear. It is the various forms of the use of force that have a certain level of gravity that involve or are tantamount to the sending of troops. And this concept is very closely connected to the concept of aggression. But you'd have to take into account that these are not interchangeable concepts, armed attack and aggression. They're not interchangeable, but the exact difference between them is very hotly debated in the international literature. Some authors say that it is a difference of degree, aggression being a very grave form of the use of force that is above armed attack, but is well, armed attack will be below it, but above it will be aggression, right? So and below them would be the use of force itself as a more general concept. So these authors interpret the ICJ's decision in Nicaragua as meaning that there is some sort of gradation between different forms of the use of force. Others say that there is a gradation between the use of force itself and the concept of armed attack, whereby armed attack is one of the grave forms of the use of force. And that aggression does not refer, or is not a term that refers to the gravity of the use of force, but rather to its justification, in the sense that aggression would be the use of force that is not otherwise justified. My opinion is that aggression as a concept refers to the second conceptualization of it. That is to say, aggression is the use of force by a state that is not otherwise permitted by international law. And so aggressive force would be a force that is not defensive and that is not authorized by the Security Council, in my view. And this is something, again, that is very hotly debated, and we can have that discussion at a later day. If you want, you can send me an email and we will have that discussion. Another factor that is important is that not only self-defense is part of an international regulation on self-help measures, it is also a smaller part of a larger UN collective security system, as I explained before. And so many authors and many states like to conceptualize self-defense as some sort of inherent and absolute right to defend one's territory in any circumstance. But what we see in the UN Charter system is that this cannot be further from the truth. The UN Charter system regulates self-defense within Chapter 7. And in fact, it is the final part of Chapter 7. Chapter 7 dealing with measures by the Security Council to preserve or restore international peace and security. And so, for example, authors like Professor Diret Tladi, who, as I mentioned, now is a member of the ICJ, they take this as a factor of interpretation. Why is self-defense regulated in the Charter within the powers of the Security Council, within Chapter 7, in the maintenance or restoration of international peace and security? Well, they say the right to self-defense under international law is an exceptional right because it encompasses the unilateral use of force. And since the UN system is based on the principle that unilateral use of force is prohibited, then self-defense needs to be subject to very exceptional limitations. And they also say, and this is a very important assertion, very interesting, in fact, that self-defense is a temporary right, a temporary right. Why do they say that? Well, Article 51 of the Charter says that the inherent right to self-defense is without prejudice to the functions of the Security Council under Chapter 7. And in fact, it says that any exercise of self-defense needs to be notified to the Security Council, and this right ceases to exist when the Security Council adopts measures under Chapter 7. And so it appears that from the perspective of the UN Security Council system and the security system, the collective security system in general, the right to self-defense is conceptualized as some sort of temporary, exceptional right. Now, whether this is the same under customary international law outside of the treaty system established by the UN Charter is a discussion that can be had. And in fact, it's again, a very hotly debated subject. Now, to which requirements is the principle of self-defense subject? Well, the one that is prominent in Article 51 of the Charter, other than the obligation of notification and what I said about its temporary nature, is that the right to self-defense has to be exercised in response to an armed attack. I already explained what an armed attack is, according to the ICJ. But the question is, can a state exercise the right to self-defense when it hasn't been attacked yet? And if it hasn't been attacked yet, when can the state resort to self-defensive measures? And this is perhaps the most difficult question in the context of self-defense. In fact, it is the subject of a long-standing discussion regarding the concept of anticipatory or preventive self-defense. And so to resolve this question is not something that would be within the scope of this lecture, but I will give you some elements that are relevant for you to understand why this is so difficult. Well, there is the concept of anticipatory self-defense that describes the use of force avowedly in self-defense before the perpetration of an armed attack. So if the armed attack is here, then anticipatory self-defense will be any time before this. And so before this, we have various different stages. If the armed attack is ongoing, if it is about to impact, or if you're trying to intercept it, it hasn't yet impacted your territory, then authors refer to self-defense as interceptive self-defense. Interceptive, because it is intended to preempt in a way, but it is intercepting an attack that is already ongoing. The second concept would be preventive self-defense, which is when you know that you're about to be attacked. You have evidence, tangible evidence that you're about to be attacked. For example, when Ukraine saw that Russia was displaying its army in its frontier, in its international border, this could be considered evidence that there was a future intention to use force, for example. And in fact, it would be considered a threat of force under international law. So you have evidence that you are about to be attacked, but the attack hasn't been launched yet. So this would be preventive self-defense. You are preventing the attack. And then you have a concept that is even before that from a temporal spectrum, which would be the use of force when you have no tangible evidence that you are about to be attacked, but you know that a future attack is possible. You know that a future attack is plausible, and you want to, even before the idea has arisen in the mind of the other state, you want to destroy the capabilities of the state to attack you. So this is even before in the temporal spectrum. And this is considered preemptive self-defense. And myself, I have in the past discussed a further subject, a further concept of self-defense, which I call putative self-defense, which is when you believe that you're about to be attacked, but you are wrong, you are incorrect. Your analysis of the evidence was flawed, and you anticipated an attack that was never going to happen. So from my perspective, putative self-defense would be even before preemptive self-defense, because you are not dealing with a future attack, you are dealing with a non-existing attack. And then after the attack has already taken place, you have reactive self-defense, self-defense that reacts to an attack that is already launched, that is already impacted your territory, and you are responding to it according to international law. So which spectrum is recognized by international law? Again, this is very hotly debated. Perhaps the most hotly debated subject in self-defense. Some say that all of them are recognized. Some say that some are recognized, particularly some say that reactive self-defense is recognized, but not anticipatory self-defense. Some say that some degree of anticipatory self-defense is recognized, but not other degree. And some say that only interceptive self-defense is recognized, but not preventive. So it really depends on who you ask. If you ask me, and if you ask authors like Professor Diret Ladi or Professor Tom Rice, if you ask them, they will tell you that the practice of state appears to be that self-defense is permitted in respect of the reactive spectrum, the interceptive spectrum, and sometimes the preventive spectrum, because in those cases, the attack is a tangible reality. But anywhere else before that, when the attack is not a tangible reality for which you have evidence, then you are acting not in the exercise of self-defense, but contrary to Article 2.4 of the Charter, because you are no longer responding to an armed attack. But as I said, this is very hotly debated. It really depends on who you ask and which evidence you look to. Some states say that the whole spectrum is recognized. Some say that no part of the spectrum is recognized before reactive self-defense. So I encourage you to look at the state practice, to read the literature, and to form your own opinion as to which forms of armed attack are recognized as authorizing the use of force in self-defense. Now, further requirements in this respect are necessity and proportionality. If you look at Article 51 of the Charter, you will not find them. And the reason for this is that necessity and proportionality are customary requirements for the use of force in self-defense. This has been recognized in multiple occasions by the ICJ, foremost among which are the Nicaragua case, the armed activities case, the Wall Advisory Opinion, and the Nuclear Weapons Advisory Opinion. So this is a very reiterated practice by the ICJ to recognize that necessity and proportionality are requirements for self-defense. And they accord with the principles of international law in general. And in fact, they also accord with the principles of the UN collective security system in general. Now, what is the difference? Well, necessity means that there is no alternative means to repel the attack. For example, if you could have been able to repel the attack through diplomatic means, then the self-defense was not necessary. And proportionality means that the use of force in self-defense is commensurate to the attack against you. So in proportionality, there are some considerations to be made. According to some, the parameter to determine how commensurate the self-defense is to the attack is whether it is proportionate to the aims of self-defense. So for example, self-defense under that theory can be more intense than the armed attack against you, if that is proportionate to the purpose of defending yourself. Some say that it has to be proportionate to the armed attack itself. And so you have to attack in the same intensity, with the same gravity as the attack against you. And others say that it has to be proportionate with the consequences. And so, for example, if you use force in self-defense, you cannot use self-defense in a disproportionate manner so as to cause more injury than is necessary to achieve your ends. And within within that last theory, it is argued that the protection of civilians is an important consideration, in the sense that it cannot be disproportionate from a humane perspective. Myself, I believe that all three of them are to be considered. And the reason I say that is precisely what the court said, the ICJ said, in its 1996 nuclear weapons advisory opinion, where it said that proportionality involves the consideration of the protection of international humanitarian law principles, as well as the performance of international environmental obligations. And so from this, you can extract the principle that it is not only the aim of self-defense that determines the proportionality of the attack, but rather also the humanitarian and environmental consequences of the self-defense. And so, for example, if you cause excessive environmental damage or extensive humanitarian catastrophe, then your act is no longer self-defensive and you are in violation of the principles of the collective security system. So, this is something that you have to analyze on a case-by-case basis. And I would encourage that you take into account also the principles of the UN. One of those principles is the protection of human dignity and the protection of human rights. And so to say that self-defense can be exercised to the detriment of human rights, to the detriment of environmental law, to the detriment of humanitarian law, and to the detriment of the recognition of the inherent dignity of the human person would be antithetical to the UN system as a whole. So that is my personal opinion. And I encourage you, once again, to look into it. The second exception is United Nations Security Council authorization. Now, as I mentioned before, the UN is conceived of as a monopoly of force, but this monopoly of force is imperfect. And this monopoly of force is granted upon or tasked with or given to the hands of the UN Security Council. According to Chapter 7, the primary responsibility of the Security Council is the maintenance and the restoration of international peace and security. The process by which the Security Council takes these decisions to adopt measures in response to a threat to international peace and security is a very broad subject. If you want, through the Jessup administration, we can suggest some literature, but remember that we cannot answer any sort of question that may be addressed in the Jessup problem. So if already your question relates to that, know that we cannot answer it. I will address some of the provisions of Chapter 7 that I believe to be very relevant to this question. So first, the Security Council's authorization under Chapter 7 has a very specific temporal and substantive scope. Under Article 39 of the Charter, the Security Council can only adopt these measures in response to three situations: a threat to the peace, a breach of the peace, and an act of aggression. So what each of these means is not defined in the charter. Perhaps it is easier, although not easy itself, to gauge the answer to this question through the practice of the Security Council. So a threat of the peace could refer to a situation in which the peace has not yet been breached, but there is a particular situation that puts the security, the international peace and security in danger. For example, the commission of international crimes like genocide or crimes against humanity could, in some situations, be considered a threat of the peace, a threat to the peace. Now, the concept of an act of aggression I have already addressed. From my perspective, an act of aggression is the use of force that is not authorized, is not permitted by international law, or has no justification in international law. So the unilateral use of force without justification could be considered an act of aggression. And a breach of the peace would be a situation in which the subsequent acts of aggression between two or more states are so recurrent, so constant, so brazen that you can consider that the peace has been broken, it has been breached. Although, if you look at the practice of the United Nations Security Council, sometimes the concept of a threat of the peace is used when in truth we have an act of aggression. Or for example, a breach of the peace is used as a concept when in fact we actually have only a threat of the peace. So it really depends on how this issue is negotiated from a political perspective within the council itself. The law is an important factor, an important consideration, but it really depends on how the Security Council looks at the situation on a case-by-case basis. So these concepts can, in some cases, be rather interchangeable, depending on the gravity of the situation and the principles and the interests involved. Now, under Article 40 of the Charter, the Council has the obligation to prevent aggravation of the situation. So the Council can, for example, under Chapter 6, promote or recommend the resolution of the dispute through peaceful means, so as to prevent aggravation, or to adopt measures such as the establishment of a peacekeeping mission with the consent of the states to prevent aggravation, the establishment of a demarcation line or some sort of buffer zone between the states to prevent even the misunderstanding that the use of force is to be pursued by one of them. So these are some sort of measures that are intended to prevent aggravation between states. Under Article 41, the Security Council can also dictate measures that do not involve the use of force. This can be the severance of diplomatic relations or the application of sanctions, which may be political, they may be economic, etc. Under Article 42, the Security Council can authorize the use of force. So this is an exception to Article 2.4 of the Charter. This can be through air, sea, or land forces. Now, as you know, the UN does not have its own army. And so the UN basically acts or operates on the basis of voluntary contributions of troops. And part of this voluntary contribution of troops is done through the system of peacekeeping. So very many states have memorandums of understanding and other sorts of agreements with the UN through which they will they agree to, according to their own availability, to propose some sort of officials, soldiers, etc., to participate in the UN Security Council peacekeeping forces. But to this date, we do not have a full-fledged application of such principles, because this is based on voluntary contributions of troops. Another factor, as I mentioned before, is that the principle of self-defense is recognized within Chapter 7. I have already expressed what are some of the legal implications of such a recognition. Now, Article 25 of the Charter says that the decisions of the UN Security Council are binding, so they create legal obligations for states under the Charter. Now, whether such decisions encompass decisions under Chapter 7 only or under other chapters of the UN Charter is not an issue that I can answer to you, because it is precisely one of the contended issues this year. But take into account that Article 25 says that the UN Security Council's decisions are legally binding. And another important factor is that Article 103 of the Charter says that Charter obligations prevail over any other obligation established under any conflicting treaty. So, for example, if the state has commercial obligations within the WTO system, the measures adopted by the Security Council in the exercise of its functions under the Charter would prevail over those obligations in the specific case. This doesn't mean that conflicting treaty provisions are null and void. It only means that the state is allowed to misapply them, to not apply them in specific cases if they are inconsistent, and to the extent that they are inconsistent with their Charter obligations under, for example, Article 25. And this is, again, and I have to repeat it, analyzed on a case-by-case basis. So are there any other exceptions? I have already expressed my own personal view that there are no exceptions other than self-defense and Security Council authorization under Chapter 7. Some say that humanitarian intervention is recognized in the absence of Security Council authorization. They take this on the basis of human rights obligations or the doctrine of responsibility to protect. I personally don't believe that there is sufficient state practice to justify this norm under international law. And even if there were, you have a very high standard, because remember that the prohibition of the use of force is a rule of jus cogens. And so if the rule of jus cogens has been modified, according to Article 53 of the Vienna Convention on the Law of Treaties, this exception also has to be of a jus cogens character. Others say that consent is an exception. I personally take the view that is taken by Professor Diret Ladi in his book on the extraterritorial use of force against non-state actors, in the sense that if there is consent, in truth, there is no force, because you have the authorization of the territorial state. So it is not that consent is an exception to the use of force. It is rather a situation in which force is not being used. The question of use of force does not arise, in my view. Of course, if you look at it from the perspective of the articles on state responsibility, it would appear that since consent is recognized in Article 21 or 20, I believe, as a circumstance precluding wrongfulness, then using that argument, you could say that consent is an exception. But I personally do not believe so. I believe that it is rather a situation in which force has not been used because there is consent or authorization by the territorial state. Now, finally, another exception that is raised is that self-defense can be utilized against non-state actors in the territory of another state without the consent of that state, so long as that state is unwilling or unable to curb the non-state actor threat. I personally do not believe that such an exception exists. I believe that in no circumstances Article 2.4 obligates states to ask for the consent of the territorial state, or otherwise to ask that state to perform its own primary responsibilities under the Charter to ensure that such an armed threat does not spill over into the territory of another state. Now, there may be one exception, for example, when the non-state actor is acting in a way that is attributable to the territorial state. In that case, an armed attack by the non-state actor is attributable to the territorial state. Therefore, it is an armed attack by the state, and the state that is the victim of that armed attack can legally, under Article 51, resort to the use of force in self-defense. But there is a distinction there to be made, and it is a very important distinction indeed. Another concept that is relevant is the concept of the crime of aggression. I will not be delving into this too deeply. Just know that the crime of aggression is regulated in Article 8 bis of the Rome Statute that establishes the International Criminal Court. the court's jurisdiction over this crime was activated in, I believe, 2019. A lot of states are not parties to the Kampala amendments where this crime was introduced. Article 8 bis recognizes the crime of aggression as consisting of a crime under international law, whereby a person that is in the position to control the political or military action of a state, where that person plans, prepares, initiates, or executes an act of aggression, which by its nature, gravity, or scale is inconsistent or is manifestly inconsistent with the UN Charter. And in fact, the Charter reproduces a lot of the practice, rather the Rome Statute reproduces a lot of the practice by the UNGA in the definition of aggression. So you can see that an enumeration in Article 8 bis 2 of different acts that are considered to be acts of aggression. And what is the difference between an act of aggression and a crime of aggression? Well, it's very simple. An act of aggression is a violation of Article 2.4. It is a use of force that is in violation of international law from the perspective of state responsibility. So a state commits an act of aggression. On the other hand, a crime of aggression is a concept that involves individual criminal responsibility. And that is the reason why the Rome Statute conceives of it under Article 5 as an international crime on the same level as genocide, crimes against humanity, and war crimes. So when a state launches a use of force that constitutes an act of aggression that is manifestly inconsistent with the Charter, the state is committing an act of aggression in violation of the Charter, and the person who plans, prepares, initiates, or executes that act of aggression within the state machinery is guilty of a crime of aggression. It is a simple distinction, which can be very challenging in practice. Now, to close off this class, we have analyzed the use of force as a mechanism for the settlement of disputes. And we have analyzed that the use of force is not permitted as an instrument for the settlement of disputes. So if that is true, then what is left? Well, Article 2.3 of the Charter says that one of the principles of the UN is that member states have the obligation to resolve their disputes through peaceful means. And this is to be understood in the context of Article 2.4, which prohibits the use of force. And so states have to resort to mechanisms that do not involve the use of force. And this is precisely what peaceful settlement of disputes is in reference to. And which mechanisms are those? Well, they are codified in very many instruments. Perhaps the most authoritative recognition is in Article 33 of the UN Charter, which lists negotiation, inquiry, mediation, conciliation, and arbitration or judicial settlement. And so the mechanisms which include negotiation, inquiry, mediation, and conciliation are considered to be diplomatic mechanisms. They may or may not involve third parties, but the third party does not have the power to impose on the states a solution to the problem. And then arbitration and judicial settlement are considered to be binding third party or judicial mechanisms of dispute settlement, whereby the third party has the power to impose on the parties a solution to the dispute. And what is the basis for any of these mechanisms of this peaceful settlement of disputes? Well, if they are peaceful, if they do not involve the use of force, then their basis is consent, is the consent of all states. And precisely that is the principle that permeates the UN Charter and international law in general, that states need to have consensual mechanisms for the establishment of international law, but also for its application, so that the rights of states under international law are not undermined and are not denied. Another question that may arise is whether there is any hierarchy between these mechanisms. For example, some say that you cannot go to judicial settlement if you haven't yet exhausted negotiation, mediation, or conciliation. What you have to understand here is that there is no obligation under general international law to resort to any of these mechanisms. They are all at the same level in the Charter. They do not supersede one another. And so it is up to the states to decide when they resort to negotiation, when they resort to inquiry, or when they resort, for example, to the ICJ. This was recognized by the ICJ itself in its decision. I believe it was its jurisdictional decision in the what case was it? The land and maritime boundary case between Cameroon and Nigeria. And in its jurisdictional decision, the court said that there is no hierarchy or any sort of superposition between the mechanisms of dispute settlement in Article 33. They can not only be applied in any order, but they can also be applied simultaneously. A state can be negotiating a dispute, and in pari passu, to use the phrase used by the court, in pari passu, or simultaneously, the state can refer the dispute to the ICJ or any other arbitration or judicial settlement mechanism for which there is consent between the parties. So there is no superposition, there is no hierarchy, unless the parties agreed that such hierarchy should exist. For example, some compromissory clauses in treaties say that before going to the ICJ, states have to try to resolve the dispute through negotiation, through mediation, through conciliation, etc. One example of this is the UN Convention Against Transnational Organized Crime and the UN Convention Against Corruption. Both of those contain mechanisms for the settlement of disputes before the ICJ, but before that, states have to exhaust diplomatic means of dispute settlement. Another example is the Vienna Convention on the Law of Treaties itself. If you see Articles 65 and 66 of the VCLT, when there is a dispute as to the validity of a treaty that conflicts with the jus cogens norm, the states have first to circulate a notification to all states to the treaty of their intention to declare their own participation in the treaty null and void for any reason provided for in the convention. And if the convention, if the treaty itself is considered to be contrary to a jus cogens norm, for example, then the treaty is illegal, it is invalid from the perspective of that state. That state has to signal the intention to declare the treaty invalid to all of the other states. So there is a mechanism of a diplomatic negotiation. If in a period of 3 months, states do not oppose such a notification, then it is considered to be a sign of acquiescence or of consent, and so the state can declare the treaty void. If there is opposition, then the states have to go to the ICJ, and that is the mechanism that the VCLT recognizes when one state asserts that a treaty is contrary to a peremptory norm of international law. So with this, I will end the discussion. I don't know if there are any questions regarding any of the subjects that we have addressed. I would also like to clarify, as you could see in the emails that were circulated to you, that this is the last session of this school. So if you have any question, please make it now, or you can send it to the organizers, that is to say to Gloria or to myself, and we will be glad to answer it. So if there is any question, this is the space to do it. Go ahead, Jose.
Hi, sorry for the bother. I just wanted to ask you, besides the case you mentioned about the Cameroon, is there any case law where the Pacific settlement of this chapter has been interpreted somehow?
Great question. So to my knowledge, I think there are some, but I do not remember them at this moment. And even if I did remember them, I don't think I am in the liberty to tell you, because I understand that chapter 6 of the charter is one of the subjects addressed in the Jessup problem. So I don't believe I am allowed to give you that answer, even if I had it. So yeah, maybe you can start with Cameroon versus Nigeria. You can work from there. I believe that there may be more cases, but I do not have them at hand at this moment. I don't know if there are any other questions. No? Excellent. So with this, I would like to close this year's Jessup School for Latin America. It was a pleasure to have you all. I hope this has been instructive for you. I hope it is helpful in your participation in the Jessup, either next year or in any subsequent year. Or if you're not a member of a Jessup team, I hope this has been a helpful introduction to international law. If you have any questions, you can send it to us. But otherwise, thank you for connecting, and I hope you have a nice night.
Thank you, Professor.
Thank you very much.
Thank you very much, sir.
This evening.
Was there anyone who spoke? I believe someone said, excuse me.